The first thing that woman tried to take from me wasn't my orchard, it was my reality. She rolled up in a pearl-white Escalade behind a sheriff's cruiser, stepped out like she was invading a small country, pointed at trees my family had planted before she was even born, and told me to shut the whole thing down by sundown. Then she threatened to bulldoze it, which was a bold thing to say considering the clubhouse she ruled from was sitting on rights I could legally use against her. My name is Reuben Calloway. I'm 51 and I own 17 acres in Harrow County out in the Blue Ridge foothills of Virginia. My grandfather bought this land in 1958, planted apple, pear, and cherry trees, and used to say a man who grows food can't be fully broken. My father kept the orchard alive through drought and bad harvests. When he died in 2019, he left it to me free and clear, deed, survey, tax records, all clean. I used to be a land surveyor, 28 years of reading plats and learning one truth. Most people ignore paper remembers longer than pride does. That mattered when Sycamore Bluff Estates got built next to me. Big houses, polished signs, tasteful colors, the whole HOA fairy tale. Their first president had common sense. We shook hands, he understood my orchard had been there for 60 years before his bylaws existed, and we never had a problem. Then he moved to Florida, and Geet Whitmore took over. Geetie ran that HOA like it was her own private kingdom. She sent violation notices over wind chimes, mailbox angles, ornamental grass, outdoor cushions, all that tiny, joyless nonsense people call standards when they're really just bored and mean. I didn't think much of it because my property wasn't in her HOA. I was wrong. She'd apparently been building a file on me for more than a year. Photos of my irrigation pump, complaints about compost smell, reports about my deer fence, my farm stand sign. Even runoff, she claimed, threatened HOA common areas. Every county inspector who came out found the same thing: nothing wrong, nothing illegal, nothing actionable. But she kept filing. The point wasn't to win quickly. The point was to create a pattern on paper and make me look like a problem. My neighbor Wendell Oakes, a retired attorney who lived inside Sycamore Bluff and disliked Geetie with real discipline, came by one evening with a manila folder and told me she was talking to a lawyer about a nuisance claim. That got my attention. In Virginia, farms like mine have protections, especially when they existed long before subdivisions moved in beside them. The orchard was there first and under the right to farm law that matters. I called the county planning office, got a formal letter confirming my operation was grandfathered and compliant, and made copies like a man who had learned not to trust peace. Then I did something Geetie hated even more than being told no. I got ahead of her story. I called the local paper. They ran a Sunday feature about the orchard, my grandfather, the old photos, the history of the land. Suddenly, I wasn't the nuisance next door. I was the third-generation orchard owner trying to keep a family place alive. Folks around town rallied. Even some people in Sycamore Bluff quietly let me know they were on my side. So Geet escalated. Her attorney sent me a letter claiming my weekend farm stand violated Sycamore Bluff's HOA covenants. I laughed out loud in my kitchen. Their rules had no authority over my land. Still, I knew the letter wasn't about logic, it was about pressure. So I hired Marcus Delgado, a real property attorney out of Staunton, who had the dry tone of a man who'd spent years watching arrogant people pay for avoidable mistakes. He sent back a response that politely shredded every argument they had. And then I started digging. I went through old plats, title chains, subdivision filings, easements, conveyances, every scrap of paper tied to Sycamore Bluff. Late one rainy Wednesday with thunder over the mountains, I found something strange. Then I found something worse. I verified it 3 different ways and called Marcus. He listened, went quiet, and finally said, "Reuben, do you understand what you're sitting on?" "I think so," I said. "Keep it in your pocket," he told me, "until she goes one step too far." She did. First, she called the health department over my compost, claiming it was a hazard. Then she found 2 adjacent homeowners willing to sign affidavits saying traffic from my Saturday farm stand disturbed their peace. Then her attorney filed for an injunction to shut my farm stand down while the nuisance case moved forward. That was the moment I opened the envelope. Back in 2015, when the developer built Sycamore Bluff, they carved out a parcel for the clubhouse, pool, and parking lot. Buried in the original plat was a permanent access easement tied to my grandfather's 1958 deed. Decades earlier, he'd negotiated a legal right to cross that ground for agricultural purposes when a county road was rerouted. That easement ran with the land, which meant it survived every sale and every HOA document Geet liked to wave around. My family still had that right, but that wasn't the real surprise. The real surprise was a lien. An old one recorded years before the clubhouse parcel was transferred to the HOA, never cleared, still attached to that property like a buried landmine. Somewhere in the chain of title, somebody missed it. The debt got passed through bank mergers and name changes, but it stayed alive. Marcus and I tracked down the bank that now held it. The total was roughly $44,000. And I bought it. Not the land, not the clubhouse, just the legal right to enforce that debt. Which meant, while Geet was spending HOA money trying to shut down my family orchard, I was now sitting on a lien against the parcel where she held her board meetings. I wasn't planning to foreclose. I'm not cruel, and I had no desire to punish 47 homeowners for one woman's ego. But leverage is leverage. If somebody insists on making war, they don't get to be shocked when you learn where their walls are weak. Marcus added one calm little paragraph to our court filing, reserving all rights regarding a recorded lien interest recently acquired in property owned by the HOA. That paragraph landed like a hammer. By the time settlement talks started, Geety's attorney looked tired in the soul. Marcus laid it out cleanly, end every claim with prejudice, acknowledge in writing that my orchard was lawful, an outside HOA authority, reimburse my legal fees, and resolve the lien without hurting the homeowners. The attorney went very quiet when he understood what the lien meant, not just financially, but politically. Because once the HOA members learned their president had burned through reserve funds on a losing crusade while somehow missing a lien hanging over their clubhouse, her little empire was finished. And that was the twist Geety never saw coming. The people she'd been trying to control turned on her. Wendell and a group of homeowners petitioned for a special HOA meeting. The clubhouse parking lot was full before it even started. Cars lined the road. Inside the room smelled like industrial carpet cleaners, stale coffee, and nerves. Geety stood at the front in a charcoal blazer, jaw set, still trying to look in charge. But command gets slippery once the invoices come out. A neighborhood accountant presented the numbers. Over $38,000 in legal fees over 2 years. Reserve funds, drained dues, wasted on a fight they couldn't win. Then Marcus walked everybody through the settlement, and plain English title insurance would cover the lien. Homeowners wouldn't lose their pool. My fees would be reimbursed, and a recorded covenant would permanently block future boards from trying this again. The vote in favor was overwhelming. Then came the vote asking for Geet's resignation. A retired firefighter in the fourth row stood up and said, "With respect, ma'am, you spent my money attacking a man's apple trees." That was it. That was the whole case in one sentence. The room turned on her right there. During the open comment period, I walked to the front and told them I had no interest in taking their clubhouse, no interest in hurting the community, no interest in cruelty. I said the lien was a legal response to a campaign that had left me no other practical leverage. Then I handed out a 6-page timeline, every complaint, every filing, every dismissal, every dollar this mess had cost. Not as a weapon, I told them, but as a record, because bad leadership survives on short memories. Then I said the part I'd been carrying for 2 years. My grandfather planted his first apple trees on that land in 1958 because he believed growing food was dignity. I told them I still believed that. I told them land remembers who cared for it and who tried to rule it without understanding it. The room went quiet. Then somebody started clapping, then another, then the whole place joined in. It hit me right in the chest. Geety resigned 11 days later. The title insurance company paid out. The lien got cleared. I got my legal fees back. And yes, I made money on the lien purchase too. I used part of it to start an agricultural scholarship in my grandfather's name. The orchard went on to have its best season ever. Families came for cider, for pick-your-own weekends, for the smell of apples and cold mountain air, and something honest they couldn't find in a subdivision meeting room. That whole mess taught me something I wish more people understood. Power gets ugly the moment it forgets it's temporary. The law can protect you, but only if you know what's in the record and have the patience to let truth outlast theater. Greed is loud. Fake authority loves a costume, but documents are merciless. They don't care who raised their voice the highest. They just remember. 8 months later, the orchard is thriving, and every time I cross that old easement near the clubhouse, I think about my grandfather walking that same ground long before Sycamore Bluff had a sign out front. Geety thought she could erase history with paperwork. Turns out paperwork is exactly what buried her. So let me ask you this: when somebody uses a little bit of power to bully people who were there first, where's the line between justice and revenge? And if you were in my boots, would you have stopped at the settlement or pushed all the way to foreclosure? Tell me what you think. Who was right? Who went too far, and whether you've ever had to fight for something that should have been yours all along.